Well, hello and good evening, everybody. My name is Professor Kathy Liddell, and I'm the Director of the Centre for Law, Medicine and Life Sciences here at the University of Cambridge. And on behalf of our centre and the Cambridge Festival, I am delighted to welcome you to the 2022 Baron de Lancey Lecture in Medical Law and Ethics. We are very privileged that our lecture tonight will be given by Professor Bartha Knoppers, and I'm going to take a couple of minutes of your time just to introduce the proceedings, if I may. First of all, I'd like to say that we're very fortunate and grateful that the lecture series is supported by the university's Verheyden de Lancey Fund, which supports medical law research and teaching. The fund was bestowed by a foundation in Jersey that was set up in 1970 in memory of the quite extraordinary Baron de Lancey, who was a medic, a lawyer, and a financier, amongst many other things. Following in his footsteps, the lecture series has a long history of distinguished interdisciplinary speakers, and we're going to add to that tonight. Professor Knoppers is going to discuss whether the law appropriately regulates regenerative medical technology and whether international law might play a role in securing or maintaining that balance. We're delighted that Professor Knoppers has agreed to give this lecture because she's a highly distinguished professor from McGill University in Canada, where she founded the Centre for Genomics and Policy, which has led its field for 2 decades. And in the area of tonight's talk in regenerative medicine, she has chaired the policy committee of the Canadian Stem Cell Network, as well as the ethics working party of the International Stem Cell Forum. She has served on the International Commission on the Clinical Use of Human Germline Genome Editing, and also currently co-chairs the ethics working group of the Human Stem Cell Atlas. In recognition of this work and much more, she holds no less than 4 honorary doctorates, as well as the Order of Canada and fellowships with leading medical societies, and the Lifetime Achievement Award from the Canadian Bioethics Society. In short, I think she's made a truly inspirational contribution to bioethics and law. And I think you'll agree with me that she's an outstanding person to be giving tonight's lecture. Just before I hand over to you, Bartha, I just have 1 or 2 logistics to run through. The lecture is being simultaneously live streamed through the web for those of us who cannot be here in person. And after the presentation, we will have a Q&A session until around about 6:45, no later than 6:45. For those of you who are watching online, the chat function will have been disabled, but you can pose questions to participate in the Q&A session using the Q&A icon in the toolbar at the bottom of your Zoom screens. Your questions will be collated by the organizers for the live Q&A. And you can also give a thumbs up to the questions that you would particularly like to hear answered. And maybe we should introduce that to the setting here too. Right, so with that, I'd like to invite you to join me in welcoming in the customary way, Professor Bartha Knoppers.
Thank you, Professor Little. What Kathy left out in her introduction is that I'm here with my husband, who's a professor of international law. His name is Daniel Turp, and we actually had our first child here in Cambridge. We were working on our doctorates from France, but we decided to supplement with diplomas from the various colleges here, he, Queen's, and myself, Trinity. So when I was checking out Le Baron, I noticed that he also had Dutch origins, which is interesting because I was born in the Netherlands, and that he was from Trinity. So I immediately felt an affinity for the Baron de Lancey. And I think Verheyen, if I'm not mistaken, Veronica must be part of that family as well. She's a top European geneticist. So I'm really pleased to be here. I've worked with the Center for Medicine, Ethics, and Life Sciences. I've worked with Ron Zimmern from the PhD Foundation. So whenever we come to Cambridge, it really is like coming home. So thank you for the invitation. Thank you, Foundation, as well. I don't dare read newspapers anymore because every time I think, oh, you have to be, topical and timely, but then there's too much. I'll just take this morning. Oh no, first yesterday, 3 billion into Altos Labs here in Cambridge from Jeff Bezos for work combining immunology with cell line, cell therapy, and gene therapy. There was a parthenogenesis sort of news yesterday, again, from a lab here in Cambridge. And then this morning, we saw that an indigenous nation has sued on behalf of the salmon's right to life, saying that the salmon have an inherent right to exist, flourish, regenerate, and evolve. And I think there was also, unfortunately, the death of the first person to receive a pig's heart transplant. Now, we know there was baby Faye in 1984, but this was and it wasn't from a rejection. So this Xeno actually worked. They had to use CRISPR to engineer the pig's organ to be compatible with the recipient. It was actually that I think the poor man was just worn out from his condition. So when you're in a field like this, you don't always want to read the news because you don't want to always have things to think about. But it is exciting because when I was here in 1979, Steptoe and Edwards were here, and they graciously offered me, a lowly PhD student, having come from France, where professors are way up there. I could interview them, and my thesis was on IVF at that time, which was just emerging, and Louise Brown had been born in 1978. And so we didn't know, nobody knew should we intervene at all, how, if so, why. And I was so struck as a professor still today about how important it is to give time to your students and to make them dream that they can address important issues. So that was IVF. But then in today's context, we've sort of come back around. In the 1990s, the Human Genome Project sort of took over from the fantastical slippery slope world of IVF. And so it was map the human genome, map the human genome. I was very involved in that because it was one of the first projects that believed in data sharing and every 24 hours downloading whatever sequences had been found into an open repository. At the same time, there was Celera, the company, which Craig Ventnor, saying, join us, we'll do it for you. We'll even pay to do it for you, but we get the IP. So we had these two projects in competition to sequence the human genome. And since then, we've been trying to understand what the map says to us. But today, in 2022, we're back into more of the, pardon the expression, creationist issues of tissue engineering and gene editing and modifying and implanting and reprogramming and CRISPR editing and so on. So now, back like 3-4 decades later, while knowing life and the value of knowledge stood at the center of the Human Genome Project, today it is the making and engineering of life that more and more defines biolegality in the present time. But luckily, we've learned that today's fields are not singular disciplines, and that includes law, by the way, and includes ethics and sociology and psychology and so on. And regenerative medicine is one of the fields that really stands out as, per se, a multidisciplinary field that combines knowledge and technologies from different fields, and look at the list there, to develop therapies products for repair, replacement, damaged tissues, organs. Why don't you add CRISPR editing future generations and so on to the list? But lessons learned from 40 years, from IVF to human genome to regenerative medicine, is not just because the field is multidisciplinary, but we've realized that we need to contextualize, we need to look at the genome in terms of the environment, in terms of epigenetics. We've seen that the relationship between animals and humans and the code of one, or I think, is it the yeast? Is there a geneticist in the audience? I think the yeast genome is the closest to the human genome. That's what's very humbling. And so we realize this interconnection between the different contexts of animals, the environment, and humans, and have begun to think beyond singular fields and disciplines, and also between persons versus thing and so on. So the aim then of today's presentation is also to show you, again, by way of introduction, that there's not a legal vacuum. There's not an ethics vacuum. There's not a policy vacuum. This is the list of tools that the WHO Advisory Committee just came out with in July 2021 that already, when put together, when understood, when examined and so on, shows that we are dealing with it, if I can put it that way, albeit it looks truncated, it looks like it's already passé, but we have many, many tools at our disposition, and we don't always have to have a law against it or a law to limit it and so on. And there's many, many activities and interventions that serve to guide us across and around the world in our different cultures and our different countries. So my aim today then, and I must say, I think you saw his name on the first slide, I collaborate with a PhD student of mine, Michael Beauvais, and we have a common love for art. But he's the only one who can check out whether I'm allowed to use the art I want to use for the Creative Commons licensing and all this stuff. But he should get the credit for the choice of the slides you'll see. So I'm going to start by looking at, okay, what does the law say about, you know, person, thing, animal, human, and so on? What has the professional community done in terms of saying, if it's a serious condition, then maybe you can go ahead with mitochondrial this, or maybe you can go ahead with gene editing, or maybe you can do prenatal and so on. But what about the future? Is that filter, that professional filter, sufficient? And finally, are there any, as Kathy mentioned, international solutions that we should be looking at? So to date, just by way of the dualisms, you will see that's mainly the courts that have sort of had to decide what's property or not, or what's animal or human and so on. And it's mainly the professional associations that have looked at what is a serious condition, what is severe enough to merit giving access to prenatal or preimplantation or mitochondrial and so on. And finally, for the future, does human rights hold the promise and the strength to deal with our dynamic, re-engineered, reprogrammed futures? So in December of 2019, another legal scholar, Hank Greeley, and I published in Science, 2,000 word. I say this because anybody who thinks, well, most of you must know, I think this was 18 versions of this article without making sure the editors didn't say what they wanted to say instead of what we wanted to say. But we tried to look through the traditional dualisms in law that help us sort of circumscribe and frame and filter and allow or not allow certain technologies. So this is more, how do you define human to know what law applies? And so we looked at, obviously, the prenatal and IVF and so on that have been around since the 70s. but the pre-implantation genetic testing, which kind of removes it from decisions made during pregnancy and all the other legal rights that go with reproduction. Induced pluripotent stem cells, programming one way, reprogramming that way, going back to the original, and then reprogramming another way. Sheaths, brain activity in pigs, chimeras, as we heard about animal organs into humans, and organoids. Organoids sort of serve as avatars. You can actually create next to the patient using their cells. It's already be used in cancer. This is not a movie thing. Using the patient's own cells and tissues, a model for testing your drugs and so on, without actually inflicting anything on the patient, him or herself. So how do we define human? And we have to make sure that just because someone is seen or understood in a particular country as being human doesn't necessarily mean they're a legal person. So that's why when you see human beings, it's an elastic term that permits different countries to sign universal declarations of human rights without in any way being limited by a social, cultural, or religious or other constraints. So maxim of Roman law, I had to add women because of course it wasn't there. Law is supposed to be for the benefit of humans, men and women. But traditionally, there were two classical categories. You were either a person or a thing. A thing can be owned, a thing can be sold. So you can see why it's very important in the prohibition against slavery or selling organs to make these kinds of distinctions. But more importantly, all human beings are born free and equal in dignity and rights. So if you're recognized as a human being in dignity, which is inherent, you can ascribe in your particular society or hopefully internationally, human rights. People sometimes make lists and they put dignity, security, privacy. It's not the same. Dignity is not a human right. Dignity is inherent. It's in what defines us as humans and allows us then to ascribe human rights to respect that inherent dignity. So what about these dualisms? As first-year professor, unfortunately, I was telling Kathy this the other day, I started, I guess, 1985, and they said, we always give property law to first-year professors. Like, what? I don't know anything about property law. I don't own anything. Courses start in 6 weeks. What do you mean I have to teach property law? I don't even want to know about property law. Well, actually, it turned out to be quite handy for learning about the limits of property law, but also today about how, like with the vaccine issues around IP and open licensing and so on, it's good to have a handle on it, though I must say I'm not even sure today that but I got the highest ratings for the subject I knew the least about. I don't know what that says about professors, but it's exactly what happened. Maybe I wasn't complicated. And so person, thing, human, animal, living, dead, personal, anonymous, or anonymized. And finally, this other subject is not a legal dualism. It's a subject of last year's lecture, if I remember right. You had enhancement and therapy in sports and so on. So I put it up there just to remind you of last year. So what are these dualisms and have they really had any impact on do they serve society by allowing some sort of certitude, is that French probably, certainty, in terms of how we define and handle potential conflicts or issues? Well, I've got two Canadian cases here. Don't worry, this is not a sperm warehouse. It's only a picture that shows you that if you can't find a law on something, you work by analogy. You find a part of the law that actually by analogy would allow you to determine the rights of the parties involved simply because it seems to be the same kind of situation. So in this case, they use the Warehouse Receipt Act. I'm sure they could have used dry cleaning, the law governing dry cleaning contracts or whatever, but you can see how the courts then are forced to take existing laws that weren't meant for, who owns the sperm, who can get the sperm, what happens when the warehouse burns down or whatever. And here they said frozen sperm could be considered property. So that's one province in Canada. Then you have Ontario, another province in Canada. Both common law, though, not civil law, common law. And here in 2019, the Ontario Court of Appeal overturned a lower court decision saying that it's the contract that decides. When you go to a fertility clinic, and I've written these contracts, when you go to a fertility clinic, put everything down. Should I die? Should I divorce? Should I, et cetera, et cetera, et cetera. But and normally you would think that the contract would govern what the parties could or could not do with the frozen embryos following a dispute or death or separation or whatever. Court of Appeal said, no, neither contract nor property. You can see why they didn't want to get into that. We have a law in Canada, and it has regulations saying it's a consent. And so it's a consent model, a personal autonomy model that decides what was the consent of the parties, not the contract. So now that law in and of itself was in part struck down. Canadians, like Australians, like Germans, and so on. Health is a provincial matter, state matter, whatever. So we had to use the criminal code in order to have a national approach to reproductive technologies. And in that national approach, we could condemn criminally commercial reproductive surrogacy, human reproductive cloning. All the provinces agreed. But then there was sort of like mission creep, and they got into what would be health in the provinces. And so part of the law had been already struck down. Species identity, animal human. This is probably, and I know I'm in Cambridge, and I think the animal human divide, the classical divide, is probably the most contentious right now. And every time you think, oh, well, people are going to be against it. They're going to be against Xeno. They're going to be against chimeras. They're going to be against, when you ask them, you're quite surprised at, for instance, the first article from the United States that 59% of the US public can personally accept the process of injecting human-induced pluripotent stem cells into genetically modified swine embryos and having human tissues produced in a pig's body transplanted into human. That's the United States. I'm thinking, wow, which is usually very conservative, but their organs, their tissues, it's medical. They think it's going to be therapeutic and helpful. And similarly, in Japan, another country that's known for its quite narrow approach to genetics and to new technologies. But this is the one that I think not only typifies and symbolizes, but in a way it's like an attractor in physics. It really centers the attention of the public. And habeas corpus, as you know, goes back to the Magna Carta and was used to say, get these chimpanzees out of their cages. We have a right to see if they are alive. Imagine using the writ of habeas corpus. And finally, the judge says, okay, it's arguable that a chimpanzee is not a person, but there's no doubt that it's not merely a thing. Then last week in Switzerland, in the canton of Basel, they voted down a referendum on whether chimps had the right to life. But this week, has it gone through? Does anybody know? I keep checking the papers. Did this bill go through here in your animal welfare Bill, that you had about animals being sentient beings. That doesn't mean they're persons, but they get a special status. And this has happened in Quebec as well, where you give them a status that protects them while saying that they're not human or that they're not just simple property that you can destroy and exploit and harm and so on. I think this is the one that we're supposed to go through here in the UK this week. But while we're into, you know, what's animal, what's human, what about all the zappers and the buzzers and all the neuro, I'm thinking when Christian Barnard, I think it was in the 70s when he did his first transplant, and everyone was so upset saying the heart was the locus of the soul. And then we sort of gave up on that one. And now we thought, well, the brain is what distinguishes us from other species. Is it the fact that, okay, animals may be sentient, but is it the fact that we can reflect on our own existence that defines us as human? And, or the fact that we can project into the future and so on, because we know that elephants, for instance, can and do hold funerals, so they recognize death. So we're always on this borderline. But then the organoids that have been used, because you obviously don't want to intervene too much in the human brain, now as avatars are being questioned as to the ethics of creating such entities to work on and spare humans from such invasive kind of surgery. And the final one then is the living and the dead. Well, the second to last one's living and the dead. And if you remember way back in the 17th, 16th century and so on, you were alive if a mirror was clouded, right? Whether you were just born or whether you were dying or dead. It was. Now, of course, viability is machine or technologically determined, so those kind of criteria are no longer available. But they have been since even Roman law, respect for even when you're no longer a person because you're dead, or even when you're becoming a person because you're a fetus, but you're not a person yet, but you're a human being, but no. And we have grave robbing statutes since the medieval times, respect for the body after death. We have protection for fetuses, in quotes, that are born alive for their inheritance rights and so on. So there have always been tools in the law to ensure, and even in Quebec, if there's a car accident, a negligent driver, and the woman loses a fetus of over 500 grams. Incredible. You have to, yeah. Anyway, if she loses a fetus, she will be compensated the statutory amount, not because it's a person, but in recognition of the loss and so on. So then that brings us to data, which seems to be the new identity, if I can put it that way, as opposed to a physiological sense. And when are you a non-person as far as data protection law goes? Well, the General Data Protection Regulation, the GDPR, which no one likes, but everyone's adopting because it's the European and it's having a great influence on research that can or cannot be done and data that can or cannot be shared, says you're not a person for data protection if you're anonymous or you've been rendered anonymous via de-identification technologies. Nor does it apply to deceased persons. So I think that's pretty clear. And it has what we call in law an extraterritorial effect. We didn't adopt it in Canada, nor the United States, but you cannot work with anyone, whether commercially or research-wise or whatever. You're all under the reach of the GDPR. So what has happened to date in terms of what do we do with these dualisms? Well, there's all this wiggle. I don't know if it's wriggle or wiggle, but the courts, the research ethics bodies have all sort of fudged around by finding expressions that have existed in law for quite a long time that serve to help them, if you, in a particular situation, define who's a person, a thing, an animal, and so on. And you can see here, essentially equivalent, for instance. If you want to send data to Canada, you have to see if our protection laws are adequate. What does that mean? Either you have a ruling from the European Data Protection Board, or they've said, yes, you're adequate, or you actually say in your contract, in contractual clauses, we are essentially equivalent in our level of protection and so on. So these are the ones that were used in almost all the cases of embryos, of use of organs after death, and obviously for negligence, obviously for criminal law, and so on, in terms of giving that kind of flexibility to the courts to adjust to the issues at hand. But we're moving away from sort of the person, the autonomy, the expression of autonomy, to considering the social environment, including autonomy at a group level, in order to meet social obligations to contribute to both greater knowledge and efforts to reduce social inequity. And I think the COVID crisis and the need to share data, the need to get data. Here, you were the only country in the world where researchers could get access to clinical records, albeit a limited number of data fields, not the whole record over time, to be able to follow the clinical expression of the virus. Whereas everywhere else, we had to get an informed, explicit, written consent. Most people had died by then, and or the next of kin were too upset, and or they couldn't sign, and etc. And so how at a group level, how at an international level can we respect autonomy and at the same time consider our social obligations to contribute to greater knowledge and reduce social inequities? So if the human is unique, but we know it's not just biologically unique, but also socially contextualized, the vagueness in law does allow, it's a deliberate vagueness and probably the best tool for settling these disputes. But as we know, professionals in the field faced with real life situations aren't going to wait for the courts. So what have they developed then to allow them to what can or cannot go through? Now, severity has always been a clinical, medical, scientific determination, and criteria are right there. And we've used it since prenatal, access to new technologies, and so on. But way back when, in 2001, Dorothy Wirtz and I went and surveyed American Society of Human Genetics, European Society of Human Genetics, Canadian Society of Human Genetics, and South American. What is severe? And we only asked medical geneticists in practice. And look at that, 51 disorders across all the disorders were simultaneously listed as either lethal, serious, or not serious. So even in the profession, and you think, well, wait a minute, did everybody get, go to school? Did they all get their degrees? Most of this has to do with the fact that your determination is what the laws in your country say about reproductive health, access to abortion, prenatal diagnosis, and so on. And so you could deliberately classify, or whatever it is in English, your condition dependent, of course, on the norms of the country where you were, as opposed to purely scientific norms. And more recently, the American College of Medical Geneticists has actually started listing genes. What do you do if you're doing whole genome sequencing or whole exome sequencing and you see stuff you're not testing for, but you see it because you're doing whole genome or whole exome? Do you say nothing and wait till someone comes and says, how come you never told me, or why? So they have now every year come out since 2013 with a list of genes that laboratories should report to physicians. These are very, in quotes, serious conditions to stabilize and create an even playing field, if I can put it that way, as to what patients should receive and what physicians will receive and should communicate. But there's national academies that still use this prevent a serious disease, oversight to prevent uses other than serious. Quebec, you could one day maybe do human germline genome modification for very serious high penetrance diseases and so on. Even in Germany, one day there may be germline to avoid serious monogenic hereditary diseases. And I think there's one country that's changed the most in the last 10 years and in terms of their attitudes toward genetic research, it's probably Germany. Now, your own act used serious for testing, licensing, mitochondrial, without having a definition, which is probably a good thing. But you do have codes of practice, which give some indicators to physicians and so on as to what they should take into account. And what about the future child that will be born and so on? And the mutation, is it inheritance and so on? What if there's no treatment? Or what if there's only treatment, but it costs so much that you have to go into a lottery, like for SMA, that drug for the spinal muscular atrophy. The International Commission, I was a part of this. I must say, I really sort of grow up in these things. Said if one day hereditable human genome editing were to be scientifically safe and effective, and the preclinical data look promising, even so, it would be limited to serious monogenic conditions. And only for those for whom there are no other options. Because remember, there is pre-implantation selection possible. And this definition took 3 months of work of a commission to come to severe morbidity or premature death. And so here is a screening panel for 176 genes and classification of severity for carrier screening. What do we do? What do we do? And you can see the kind of tools that we're building for physicians in these situations. But they're objective and they're not necessarily contextual or how people see their condition. So in a study that just came out on expanding prenatal, myself and another author said, well, you can create lists. That's kind of dangerous. What if one day you have a list and someone's born with that condition and prenatal was available for free democratically in the universal healthcare system and wasn't offered or was refused? As you know, we have children who will either, or their parents and or partners would sue for wrongful birth, wrongful life, wrongful conception, and so on. And what do we do about the actual context of these couples and their child to be? This was fascinating. Why don't we ask the people who have these conditions? Let's and yes, I should have put it in yellow, but in the middle there, you'll see that the majority of participants reported good health, well-being, and capacity for quality of life, despite experiencing suffering with their condition. Notably, however, patients with later onset conditions held more negative views of their health and quality of life, and were more likely to view their condition as an illness than those with early onset who had lived with their condition. Interesting. Same, ask the citizens, ask the general public. Again, in the middle of the quote there, the results showed that the multifactorial aspects that participants considered as relevant for evaluating severity were similar to those used by the professionals. Well, that's a comfort. I mean, there seems to be some sort of convergence on what these other criteria should be. And so findings such as in our study could have the potential to strengthen the internal legitimacy among professionals. So what does this mean then for the second part of this talk about taking seriousness seriously? It's subjective, it's contextual, uncertain, and changeable. So I don't think we should get a definition of what is serious in spite of the work of the International Commission, but it has to stay as sort of a filter, a framing, a beginning of a discussion, and not get lost in series of checklists, taxonomies, and algorithms, and so on. And we have to build that sort of framework for that discussion. And one way that I think we can move out of social cultural differences and also medical tourism, because what you can't get diagnosed in one country or treated in one country, if you have the means, you can find a country that will offer those technologies. So we really need to have a different approach than solely national interventions, which represent social cultural norms of a particular country. And I would argue that using a human rights approach moves us to another level of discussion. And this is the first article of the UNESCO 1997 Universal Declaration. And that it's appartenance or a belonging to the human family that distinguishes from animals and things. And the inherent dignity of the human, and yet the diversity inside the human family. And there's an expression here at the end that belongs to public international law, which I won't go into, that is like the sea, like the sky, the human genome at the level of the species is the common heritage of humanity. So in conclusion to the second part, I will now argue in my third part that the series is just the beginning. So if series is both medical, scientific, and contextual and personal, to bring it to the next level of having some common discussion, at least, maybe not consensus, on the principles for responsible scientific and technological advances, because the values are universal, might be the way to move forward. And I think CRISPR and gene editing, somatic for the time being, with quite a bit of success, by the way, and perhaps one day germline is where we need to get our act together on human rights approach. If so, we know already of the inequalities that genetics, the genetic lottery, brings to humans, to human life. But we also have not discussed what inequalities that the genetic revolution could help us mitigate. So we could develop an account of justice that takes seriously not only individual rights, but also the potential health benefits of attending to the evolutionary causes of morbidity and disability. There you see Eleanor Roosevelt and different, it's funny that we're discussing this at a time when human rights are in great peril in the last 2 weeks or so, and totally disavowed, ignored, and run over in every sense of the word. But the potential is there, and following Second World War, the countries did come together and say, let's build a new world order. Let's work on something that we can all agree upon while recognizing national sovereignty, of course. And the advantage of human rights is that they can be conjugated, if I can put it that way, together. And they have advantages of transparency, proportionality, and recognition of the inherent dignity. If you limit yourself to moral arguments, religious arguments, or bioethics arguments, you're going to get into schools of thought, to be polite. Whereas there's a universalizing sort of potential and dimension and a reality of international legal force for human rights, belonging to groups and not just to individuals, and they impose positive rights, positive duties. So take this Article 15, which is Article 27 in the Universal Declaration. But once it's in a covenant, signed and ratified, 171 countries, you can enjoy the benefits. And yet, in the same article, if you are an inventor and you have intellectual creation, you can also have attribution. So it's recognition and attribution. You can have IP and so on. And it can only be limited to such conditions as are determined by law in the general welfare of a democratic society. So that's really powerful. And this is what we call a Cinderella right. It pretty well stayed dormant in 1948. But this International Convention of 1966 started people around, scholars around 2009 with the Venice Declaration thinking about what this right to science meant. Progress, participation, and benefit. In fact, it could be considered an individual interest in a universal public good. And Professor Yotova, who's sitting here as well tonight from Keys, which has kindly received me for this visit, and I wrote about that there was promise in this article for using a global public goods approach. And so we came to the conclusion that looking just at data and how this right has been interpreted in the reports that the countries did for the United Nations, how has data and the right of access to data been enabled by different states over time. This right to science also led to the constitution and mission of the Global Alliance for Genomics and Health, which I won't get into, but using it, saying, no matter where you are, if you want to join this alliance to share genomic and health data, only thing you have to agree to is this framework for responsible sharing. And of course, it buttresses, it reinforces, it gives energy, if you like, to the right to the highest attainable standard of health, including in the Convention on the International Rights of the Child. So there's no right to be born healthy, but to the highest attainable standard of health. And that's really important in terms of access issues, as we have seen. It feeds into the right to science to health and the right to non-discrimination. The duty to make available without discrimination, especially to the most vulnerable, all the best available applications of scientific progress. So in this sense, this right then would be taking these three rights together in a way of sort of a tool, a catalyst for change in terms of the universal human rights that address emerging biotechnologies. And in particular, it shifts away from the individual autonomy, privacy, to a broader lens for the sharing of research benefits and the limits of state sovereignty. Now there is a case, it's hard to find these kind of cases with, in quotes, biotech and human rights. But here's one from 2012 from Costa Rica, where there was a ban, a legal ban on IVF. And the court, the Inter-American Court of Human Rights, ordered Costa Rica to provide IVF through state-run clinics in accordance with the principle of non-discrimination. If you're gonna, you cannot offer it at all, but if you're gonna offer it, you have to do it in a non-discriminatory way. And they used the American Declaration of the Rights and Duties of Man and the different articles. Interesting, they have founding a family, which isn't found in every constitution or every declaration as a human right. So to conclude this third part, if we were to take a human rights approach, the advantages are their universality, their flexibility, their legitimacy, and the fact that they are contextual. And we could take the 3 human rights as well, and I think really have a sort of a powerful framework for the future of regenerative medicine. So in conclusion, maybe I should have added an S on our future for futures. And I was inspired in working on this conclusion by this book that just came out today. I went to Cambridge University Press. They dug it out of their basement. It's today that the book has been released. And it's a Festschrift in honor of Graham Laurie called Law and Legacy Medical Jurisprudence. And in writing to Graham about this book and what is he doing in Edinburgh right now, he said, well, when you're thinking about the future, how vulnerable are we making ourselves with, sort of going on the bandwagon of new biotech, new regenerative medicine? And in particular, in relation to data, he said, we need to think more about how the holding and processing and manipulation and use and deployment of data comes with obligations, not just to actual living persons, but to the future generations. And he said in a personal communication again, that we should start thinking about the future us, and not just, Chinese gene edited twins, but beyond the immediate sort of crises. And he said, in a sense, the future versions of ourselves depend on the ways in which our data are or are not used. And so vulnerability is a series of layers, as Florencia Luna said, not labels. And are we making ourselves vulnerable? Are we robbing future generations in advance of their human rights, however defined? And who are, or who is the future us? So the scale is international. This is incredible. This is a retina, by the way. I don't know if you can read it at the bottom. It's amazing. Anyhow, so the scale is international, and both the International Commission on Heritable Gene Editing and the WHO said we need scientific engagement, we need open science, we need policy toolkits with an S probably, and interestingly said we need whistleblowing. And so we went running everywhere. What international approaches, laws, covenants, agencies use whistleblowing? Because in the case of the Chinese twins, as you know, there were many, many scientists aware of what was happening, both in China and in the United States, but no one, there was no place to go to say anything. And the only place we could find whistleblowing was in the World Anti-Doping Agency, WADA, which had set aside and created a special independent whistleblowing office. You can work internationally, hopefully, consensus using human rights, which is more dynamic and more epigenetic and interesting, but you have to have your own house in order, so to speak. So the national level, licensing bodies, oversight bodies, funding restrictions. If you don't publish your data, if you don't register what you're doing, you can't get funding, et cetera. And you need public engagement. Well, everybody says that. Let's have public engagement. Well, I went through this, and I tell you, this is way back in 1989 to 1993, 17 cities every night. Every person got 20 minutes, whether they were the top scientist or someone that had a particular thing to say that might have nothing to do with the subject matter. To be democratic, of course, everybody got 20 minutes. It has to be done properly. Let's put it this way. It was a free-for-all, even though the timing was democratic. And everyone got to say what they wanted to say. It actually led to, police protection, mail being screened before you received it, in case you were told you were going to be burned in hell, which happened a lot, by the way, and so on. So if we do public engagement, how do you do it in an open, transparent, and reasonable way where personal or religious or other views, and it was incredible. Sometimes the religious views and the anti-tech or would actually be saying the same, holding the same position. So there was a lot of crossover between, you know, different positions. So if you do this, you have to literally learn from the sociologists and psychologists how to do public engagement in a respectful way, both for the subject matter, but also for the participants that are part of it. But there's no doubt that it's the need to go towards international governance that is the where the engagement should be. So maybe it should be UNESCO, maybe it shouldn't be WHO. They're mainly physicians there. Maybe UNESCO is the right place for these kinds of consensus bodies. So here are some of the suggestions about oversight, adherence to principles, a scientific advisory committee to say this class of science is now safe internationally. Not wait till someone publishes it and then everyone goes haywire. And again, the International Commission said we need ongoing evaluation. Have you reached certain milestones? We need debate on new classes of use, democratic debate, and accountability mechanisms. Likewise, the WHO came up with a whole series of recommendations, including having a registry. Who's doing what, where? Just say what you're doing. You might succeed, you might not succeed. Whistleblowing, they also added it. And they made a particular plea, a subject the commission did not get into, for equitable access and capacity. So some sort of consensus on what you do with IP. And their registry then is there. I don't know, and I can't tell by the number of trials as to how effective it is. So if deliberate consensus then is the root of the future, I think we need to sort of, in my last two slides, think about procedural justice, if you like, vis-a-vis future generations, and bring some sort of coherence, recognizing that countries are sovereign, that they have their own social, cultural, and so on. But is it the human rights, values, principles, then that can bring that coherence? Can we look at, you know, ecosystems approach and understand that regulations, principles, tools, and so on are not static. They're not standards. Can't believe it when we have discussions on the GDPR. Everyone says, oh, but article so-and-so says such and such. I said, yeah, but you're supposed to interpret it. You're not just supposed to just read it like, you know, it's not a standard. It's a legal disposition that can be argued and interpreted relative to the main regulatory objective. So the best piece of news in this very sad last 14 days and so on is that a beautiful piece of work did come out from UNESCO in November 2021 after 2 years of consultation with all their commissions around the world in different countries who could comment, write in, etc., on open science. And IP is recognized in there. It's not versus, open versus property stuff. It's really a very well-balanced and I think if we are going to take a human rights approach, that it has to be one based on following this recommendation, and the text is really something you should all read. But in the meantime, since we're kind of worried about what's human, what's animal, what's thing, and property and so on, don't forget to answer this, which you probably have seen on your computer when you go on into a database or whatever. Don't forget to confirm that you are human. Thank you.